In producing our 8th B2B Synergy podcast with bankruptcy attorney Mark Forsythe, I realized just how little I really know about the different professions and professionals in our Power Partners USA network. And it's my job to help our members communicate their expertise without asking a lot of their time. So the podcast is an invaluable source of information as our members can freely describe their services and the intricacies of their businesses in their own words. It is information that leads to ideas and action. Bankruptcy law is an example, and breaking news. I did not know diddly about bankruptcy or bankruptcy law, so much that I was not even sure if I was going to be able to ask relevant questions. Mark's easy to understand and conversational interview informs not only bankruptcy law basics, but also strategies on using bankruptcy law. Professionals that should listen to this podcast are CPAs, accounting professionals, tax professionals, business attorneys, business litigators, estate planners, commercial and real estate professionals. However, all business owners should know what the bankruptcy law is about, just in case they need it or know somebody who does. The big takeaway from Mark is to call him early in the bankruptcy process to get the best outcome. This episode is the first of 2 parts because of the amount of useful information we have recorded. Enjoy and learn. Welcome to B2B Synergy, the Power Partners USA podcast, your exclusive guide to discovering the potential of B2B partnerships. I'm Alan Armijo, owner of Power Partners USA business-to-business introduction and referral service. Our members are B2B professionals who team up to provide each other repeat referral business or collaboration. Today's episode shines light on new Power Partner USA member Mark Forsythe, partner at Forsythe and Hodges, LLP. Mark, I'm really looking forward to this conversation in order to get an understanding of bankruptcy. Is it a subject that people typically try to avoid?
Yeah, it's kind of like going to the dentist. You have to go, but you're not looking forward to it. So, but yeah, it's unfortunate. It's part of the doing business, and sometimes you run into financial problems. And a capitalist society has winners and losers, and sometimes things happen. They're out of your control that you can't help. You have a major customer that doesn't pay your bill, or you have a medical catastrophe, or get hit with a lawsuit. So sometimes it's very unavoidable.
Well, can we start out for our listeners in just talking about a few definitions, terminology that for those who might be aware, can you just kind of give short explanations of the different types of bankruptcies like Chapter 7, 11, and 13?
Yeah. So Chapter 7 is just liquidation. And so anyone could file a Chapter 7. It's really only effective for individuals because only individuals receive a discharge of their debts. A big misconception out there is if I want to shut down my company, I file a Chapter 7 and the company goes away. It doesn't actually go away. All that happens if an entity files a Chapter 7 is that the Chapter 7 trustee attempts to find assets to pay creditors. And then once that process is done, they close the case and the entity is sitting there basically as an empty shell, still can be sued. And so I rarely recommend Chapter 7s for entities. That's a big misconception out there. It's much better just to try to voluntarily dissolve, but you don't achieve anything through a Chapter 7 for an entity. And then a Chapter 13 is a regular income earner reorganization. It's only for individuals. There's debt limits and income limits. And it's really for those people who are behind on their home mortgage, that want to put that delinquency into a payment plan that they're unable to achieve through a lender. And then there's one other chapter out there. I won't get into Chapter 9s, which are municipalities, or Chapter 12s, which are for farmers. Chapter 15s are for international entities. But there is a new section of the bankruptcy code called Subchapter 5. It's a subchapter of Chapter 11. And so I actually mentioned Chapter 11. Chapter 11s are reorganizations. Chapter 11s individual can reorganize or an entity can reorganize. And you can use it to not only reorganize, you also can use it to maintain possession of all the property of the entity or person filing bankruptcy. In Chapter 7, you pretty much hand over the keys to all your property to the trustee. And the trustee then, if you have a house and you can have protected by your homestead, the trustee's not going to have the keys to your house, but they'll give the property back to you. In Chapter 11, the debtor maintain possession of all of its assets. And so they can use that process to reorganize or to have an orderly liquidation. If you have a lot of personal guarantees for an entity's debts, the personal guarantor wants a orderly liquidation to maximize the value so that the personal guarantee doesn't get hit that hard, if at all. Now, a new subchapter of Chapter 11 called Subchapter 5, very, very effective. I could probably talk about this for half an hour, but just very simply, it's if you have an entity or an individual with less than $7.5 million of unliquidated debt. And it's a much more streamlined way to get reorganized. So I'll just kind of leave it at that. I literally could spend a half an hour talking about that.
Okay, well, that leads us to, can you explain your legal services as a bankruptcy attorney and in terms of any or all of these as well? What do you typically provide?
We really do it all. If it's a Chapter 13, I will typically refer it out. Those are set fees. It's a really cookie cutter type of chapter section of the bankruptcy code. Our firm really gets involved in all types of bankruptcies, but that's kind of a niche practice. And people can get it much more affordably done by those bankruptcy attorneys that specialize in that. They have a lot of paralegals, and we could not compete with those professionals from a price standpoint. And so if I get that and I see that the person, I get a referral and someone has questions, and I see they're a candidate for Chapter 13, I'll refer them out to someone I know who'll do a really good job for them. Otherwise, we represent all types of debtors in all types of businesses, industries, individuals, entities. We represent a lot of creditors when they're owed money and someone files bankruptcy on them. We also represent a lot of distressed asset purchasers. So we keep track of every bankruptcy that's filed across the United States. I have people that are interested in hotels. I have a gentleman that owns an aircraft charter service. And actually, I just sent him some information about a bankruptcy filed out in Florida for another charter service. He might want to go in there and make a bid for distressed assets. So we do a lot of that work as well. So there's not a player in a bankruptcy case that we haven't represented.
And you mentioned you assist clients with strategies or proactive approaches to use to assist them in preparing for potential financial challenges. Can you explain some of those? I think you're talking about like mergers and acquisitions and bankruptcies to buy an asset. That's what you're talking about.
Yeah, so we really try to focus too on what we like to refer to as strategic bankruptcies, right? So you're not necessarily in financial trouble, but you're in a situation, for example, with all the remote work going on right now and businesses needing less space, offices needing less space. If you have an industrial warehouse that you have 10,000 square feet and you house a lot of employees in there and all that, and now all you need is 2,500 square feet, and you got 7,500 of lease space that you're paying for on a 10-year lease, and let's assume no personal guarantee, you can use a bankruptcy to go into bankruptcy court, reject that lease, cap the lease damages at 1 year, and then exit bankruptcy and pay off, assume you don't have a lot of debt problems, pay off your debt or do a plan, but basically cap your lease damages. So that's one way to use a bankruptcy strategically. Another way is we represent a lot of owners, 100% owners of entities. They're saddled with a bunch of unsecured debt. They have a business model that works. Maybe COVID ran up a lot of unsecured debt and they just can't make the business run profitably with all this hangover debt. And hopefully the 100% owner has not dumped all his money, which a lot of 100% owners do, all their personal funds in the business. They can put the business into a bankruptcy and then just bid on the value of the assets. And that's going to be a bidding process. Everything that's sold in a bankruptcy case is by auction. But once you buy those assets out, you can buy them out free and clear of all your unsecured debt. And then whatever was paid for the assets goes and pays those creditors pro rata. And now you own your assets back from your company free and clear of all unsecured debt. Last item is, even if you have secured debt, I have a brewery up in northern LA that I'm going to be putting into bankruptcy real shortly here. They're saddled with a lot of secured debt on their equipment. And so what you can do is go into a bankruptcy and strip the liens off of on the equipment down to the value of the equipment. And so you might have liens on this equipment of $1 million and it's only worth $500,000. you could strip off the liens. So they only lien up to the value of the assets. And if there's $500,000 that was secured against that property, that'll be converted into unsecured debt that you can then pay over time in a bankruptcy plan. And when you get out of the bankruptcy case, you only have $500,000 of secured debt, right? And so the goal here is trying to shed as much of your unsecured debt as you can.
Do these strategies or techniques have any long-term negative effects on the owner?
Yeah, they can. I mean, part of the reason you're in bankruptcy is you had too much credit, for the most part, right? But most lenders, if you get into either individual or entity, you get a bankruptcy. If you can maintain good credit for two years afterwards, that you can get your A paper back. But you should plan on not having to rely upon getting credit for a year to 2 years of your business once you emerge from bankruptcy. But once you get past that, you've confirmed a plan, you've shown you can build up your credit, it can come back pretty quick.
So, I mean, it sounds like a good strategy, a good lifeline, and then you can come out at the other end after a couple of years.
Yeah, if you come to me early enough, which was one of my points of we'll go over that eventually here, Alan, is the earlier I can consult with somebody, the better. The more planning we can use. The harder cases are the ones where the debt collector's at the door, they're looking to take possession of equipment, looking to levy on bank accounts. And at that point, we have no choice but to put them into a bankruptcy to avoid those creditors from seizing assets.
Okay. So we talked a lot about specialization, but there are some other areas of specialization that differentiate you from other attorneys, right?
Yes, we really like the tough cases. There's a lot of litigation that happens in bankruptcy court, whether it be a debtor going after clawbacks on preferences, people who receive more money than they should, fraudulent conveyances. Some businesses or individuals can get wrapped up in a lawsuit. They just can't afford to prosecute anymore, and their hands are tied. And if the facts are right, we can put them in bankruptcy and try to litigate that through the bankruptcy court. Things get litigated and resolved a lot faster in bankruptcy courts. A federal court, it's going to be a bench trial. I mean, i.e., it's going to be done in front of a judge. You're not clogged up in the state court system, which can take you 2 years to get issues resolved. They're overcrowded, and in my opinion, I think federal judges, for the most part, are better decision makers.
Can we also talk about how you differentiate your law practice with your background as a CPA?
Well, we have quite a roster here. We have 2 certified bankruptcy specialists, my partner, Rob Go, of 28 years, and one of our partners, Charity Miller. I was a CPA with Arthur Young, kind of date myself here. Arthur Young back in the 80s, as I was certified public accountant in Nevada. Been practicing since 91. My partner, Rob Go, since 88. And my other partner, Ron Hodges, that joined us in 2019, he's been practicing since, I think, 1990. But we really have just a full slate of experts in all areas. And my background as a CPA really provides me that extra edge, because obviously bankruptcies are synonymous with, financial problems. So analyzing financial issues, there's a lot of financial issues that get litigated in bankruptcy court, and that really provides me an advantage.
So then, do you specialize or prefer to work mostly with debtors or creditors or some of these distressed asset purchases? Is there a preference in any of these, or in your practice, or you take them all?
I just like I just like challenging issues. For example, a Chapter 7 debtor firm, that's all they do. They had a Chapter 7 debtor who filed, and the Chapter 7 trustee, in trying to get assets for the unsecured creditors, which is what Chapter 7 trustee does. They go out there, their job, we represent Chapter 7 trustees. I've been hired by Chapter 7 trustees to go find assets. And they went after this individual's mom's and family trust to try to bring those trust assets into his individual bankruptcy case to pay the individual's creditors. And I was hired, and we actually had a trial, evidentiary hearing trial, full trial on this. And I won. And that's kind of the work I do. I like a good fight. I don't fight just fighting, but sometimes you have to fight, and that's when I like to roll up my sleeves and really get involved.
Do there have to be some extenuating circumstances for you to be able to get into a trust, assets in a trust?
It's really just the ownership issues. There's a commingling of assets. There has to be they're one and the same. Everything's got to be separated. The individual had been representing the third parties that he owned assets that he didn't really own, which the trustee tried to use to dissuade the bankruptcy judge. But fortunately, I felt I had the law on my side, and I did.
So there were some holes in that trust.
There weren't so much holes. There were just representations by the debtor, which in and of itself is not enough to make the trust liable. He can say whatever he wants. There's also due diligence required by someone. Just because someone makes a fraudulent statement, it doesn't make that person liable. There has to be what's called reasonable reliance by the person who the representation is made to. And that was one of the key issues in the case.
Okay. So then what is your client makeup? How would you describe that in general?
Just really, it's across the board. Everyone talks, you have this domino effect. I mean, you have office space that's not getting leased. Then not only is the property owner hurting, but the people that service the building are hurting, right? The people, they're probably cutting back on their cleaning services. There's commercial leasing agents who are losing out on their lease commissions, and now they're hurting. And then when they aren't getting paid the income they are, maybe they don't pay someone else. And so it's the what happens in an economy like we're at right now is there's certain pockets that are very strong. There's certain pockets that are really weak, and those weak sectors can have a snowball effect down the food chain. And so I can't really say there's any specific area right now of industry or type of individual that would dominate my client makeup right now. It's just really, it's interest rates are up. Financing is tough. If someone needs money, it's expensive money now. Collateral requirements are very high right now by most banks and lending institutions. So we'll see how that plays out. But I think there's still a lot of issues out there in the market.
So those high interest rates and collateral, those things are what lead to the bank filing for bankruptcy, right? But like in your example with the office space and that cascading effect, it's the person at the top that's filing for bankruptcy that causes the cascade. It's not like not everybody's going bankrupt in that scenario, right?
No. And I'm involved right now. It was a group called the Litigation Practice Group filed bankruptcy, and they were a debt consolidation business, and that bankruptcy filing by that company resulted in several hundred lawsuits filed in the bankruptcy court trying to claw money back from entities that were feeding the company with leads and doing work, et cetera. And so you had just one bankruptcy filing result in a couple hundred lawsuits filed in the bankruptcy case. And now those people who had really been paid money, or there's arguments that they're illegal contracts for referral of clients, whatever that is, now they're in a position to have to give money up that they can't afford to give up, right? Or they have to pay to defend the case so they don't have to give it up if they have a proper defense. So yeah, it's a real beehive when you really start peeling back flavor.
In that case, are you also involved in those other litigations or those things that you know about? What happens with all that?
Yeah, well, I got contacted. The Chapter 7 trustee in that case sent out demand letters to a bunch of these people who they're people and entities they're trying to get money back from. And then they contacted me and say, "Hey, Mark, I sued. What do I do?" I said, "Well, got to go answer the complaint, go fight it." First of all, I analyzed it and let them know, "Hey, you're going to lose. So let's just make an offer, or we have a good defense. Let's go defend it."
Okay. This is kind of a different subject, but how has the landscape of bankruptcy law evolved over the years, and what trends or changes do you foresee in the coming years that can impact clients or how you do business?
Well, I think that the advent of Subchapter 5 was huge, because the Chapter 11 process can get expensive, because one of the key differences between a regular Chapter 11 and a Subchapter 5 reorganization is if you're under the debt limit, creditors can run up and cause a lot of costs, fees, fighting over everything. And in Subchapter 5, creditors can't vote on a plan. All that happens in Subchapter 5 is they create a Subchapter 5 trustee who kind of monitors the case. My partner is on a Subchapter 5 trustee on the trustee panel. So when I file a Sub 5 case, I obviously don't get him as my trustee. And the trustee monitors the debtor, determines that if the debtor can legitimately make money, and then creditors can't vote on the plan. If the trustee says it's the best they can do, they get into a plan, they pay it back. The owners don't have to put anything into the bankruptcy case. And then after a repayment period of 3 to 5 years, depending on where we get the judge to go, you own the company. And so it's a lot less expensive. There's a lot less fighting that goes on, and it can be just a very effective way to reorganize a small company with a lot of unsecured debt.
Is that relatively new? That's the 5?
Yeah, 2019. 2019 was first passed. It was the debt limit was 2.6 million. Now the debt limit is up to 7.5 million because of COVID, and hopefully they leave it there because I try to push every Chapter 11 debtor into a Sub 5 because it's just a much easier process. You can strip down liens like I'm doing for the brewery up in Northern LA. That's what we're going to do. We're doing a Subchapter 5. We're going to strip down the liens, and the creditors, the only thing they can fight about is the value of the assets. That's about pretty much all they can argue about.
Right. Good to know. As a reminder to everybody, Power Partners USA is a B2B introduction service. We introduce business professionals to each other who can provide each other repeat leads and referrals or do business collaboration. We are targeting this podcast to your Power Partners to bring you more repeat referral business. Mark, who are your Power Partners and that give you repeat business, and how do you work with them for the benefit of yourself and your clients?
Well, I'd say CPAs. So I network with a lot of CPAs. I'm on the board for the Ernst & Young Alumni Board, and network with a lot of CPAs because they're usually the ones that can see the financial dark clouds on the horizon. That's when I just keep preaching this all the time, that the earlier I can get involved and do some planning, the better. Don't wait till, like I said, till the lawsuit's filed or the sheriff's at the door or your bank account's getting levied. See me early, and it provides me a lot more opportunities. I would have to say that 80% of my potential debtor clients that come to me, if they come to me at the right time, I can negotiate with the creditors and tell them this is where we're going to go. And 80% of the time we settle without filing a bankruptcy because I basically map out what's going to happen and get to that result without having to file a bankruptcy case. So along with CPAs, business attorneys who get involved in lawsuits. So one of the things that definitely kick a company into a Chapter 11 or a bankruptcy case is being hit with a judgment. So once you get hit with a judgment, now that creditor is going to go lien your assets. And if you file a bankruptcy within 90 days of a bankruptcy lien, a lien going on, that lien can be avoided. And so that is what can force you right into bankruptcy. So business attorneys are a great resource. Also, business attorney is suing a plaintiff, suing a defendant, and the defendant's threatening bankruptcy. So they call me up and say, hey, the guy's threatening bankruptcy. Can you come in and take a look and really tell us what's going on and are they blowing smoke? Are they negotiating? And that can get into that type of analysis as well. Real estate professionals, obviously real estate is, again, for foreclosure actions, et cetera. So that can obviously, the other side of the coin, as I mentioned to you before, Alan, is when I file a Chapter 11 case, I become actually a great referral source because in a bankruptcy case, if I have real estate to sell, I've got to go hire a real estate professional in the Chapter 11. In a bankruptcy case, if there's preparing a plan, the monthly operating reports, I typically hire a CPA to do those for us. If there's special litigation in a bankruptcy case that's beyond my expertise, I have to hire special litigation counsel. And so I become a great source for referrals needs in a Chapter 11 case. So, but yeah, and estate planners sometimes have beneficiaries. It's better for them to file bankruptcy and get rid of their debt before they might come into an inheritance. And if they do that right and don't vest with the inheritance within 180 days of filing, they're fine. And business brokers as well. So quite a range of referral sources.
Great, great. So are there any specific resources or tools that you provide to power partners to help them coordinate and collaborate with you? Like, how do they get to know you?
I hate to say it, it's really word of mouth. We don't do a lot of social media advertising, not a lot of advertising on LinkedIn. Most of the bankruptcy attorneys that do that type of advertising are the $999 roadside guys that most of them don't know what they're doing. And if you get into a bankruptcy case and you don't have it, and sometimes the worst thing you do is file bankruptcy. I'll give that advice. I'll tell the person, you should not be filing bankruptcy. So, but yeah, it's been pretty much just word of mouth. We do a lot of seminars for inside of the Orange County Bankruptcy Forum and different practice groups, trade groups. And I do presentations at various networking events. But that's pretty much how we get our name out.
Okay, good. You see a lot in the bankruptcy process, like people facing financial distress from various angles. What advice do you find yourself giving to clients to help them navigate that, the emotional and the practical aspects of this whole process?
Well, typically when an individual entity is facing potential bankruptcy, they're under a lot of stress. Getting sued, being involved in lawsuits, getting deposed, having bank accounts levied. So one of the big advantages of the bankruptcy process is it stays everything. When the automatic stay all lawsuits are on hold. They can't levy on accounts. And so it's really relieving that stress, that pre-bankruptcy stress that I find is a big advantage of clients. Now, being in bankruptcy is a lot of work, but the goal is to emerge without these pre-bankruptcy stress issues. So it's all about let's try to solve the problem. We consider ourselves problem solvers, and so it's relieving stress by solving your problems, your debt problems, and get with an end game and goal of being able to either operate your business or live your life as an individual without everyone coming after you for money, lawsuits, debt collectors. That can be very stressful. Calls. I have a lot of clients say, thank God I'm not getting those calls anymore, right? Being called all the time by debt collectors can be very stressful. And the reality is most people, I shouldn't say all, most people, they feel a moral obligation to pay back their debts, whether it makes financial sense or not. And part of my job is just to give them the reality of it is the bankruptcy laws are there for a reason. Actually, the opening line to the 1978 Bankruptcy Reform Act is the goal of the Bankruptcy Reform Act was to give debtors a fresh start. And so the goal here is to provide a fresh start. And I just tell my clients, listen, you might feel like you should be paying it back, but the reality is you can't. And so we need to take advantage of the laws that are on the book to give yourself a fresh start.
Well, and that's like a follow-up question is like, how does the creditor or the vendor on the other side of that bankruptcy react? Do they just have to wait and hope that they get paid down the road?
Well, it all depends. If you're an unsecured creditor in a Chapter 11 bankruptcy case, I would not count on getting the money. For a while, I would not spend a lot of money involved in the bankruptcy case. You might want to consult with me on whether you vote in favor or for the plan. If it's a Chapter 11, if it's a sub-5 case, you really just can't really do anything. You can't vote on the plan. So you just have to hope the debtor operates profitably and you get some percentage of your debt back. But if you're an unsecured creditor, you really, I would not put that in any kind of financial projections for your business. And hopefully you're not subject of a clawback or preference lawsuit to where you have to give money back rightfully owned. I mean, the reality of preference lawsuits is to provide an equal distribution amongst creditors. So if a creditor got paid on an old debt within 90 days of the bankruptcy, 100% of his debt, that creditor might be perfectly owed all that money. There might be no issue, but there might be creditors that didn't receive any of their debt. And so the preference actions are supposed to provide a pro rata distribution of money to all creditors. So no creditors receive more than another. And that 90-day window is just an arbitrary date they came up with back in 1978, and that's the date. So,
what's example of secured debt?
It's a lien that was either agreed to, which is the best, right? You have a consensual lien. I borrow money from you, and you take a lien on my assets, And that really cannot be avoided by the debtor. And then there's involuntary loans. You get sued by either a credit card company or a lender, or you get hit with a judgment and you're not consenting to lien. But once they get a judgment, they can throw a lien on your assets. And if you don't file bankruptcy within 90 days, that debt then becomes perfected, becomes secure. And there's nothing you do about it. And so that's the worst thing you could do is you want to keep as much of your debt unsecured as possible, because that's the class of creditors that the bankruptcy code can do the most damage to.